All right, good afternoon. We are coming live right now, and I'm going to give everybody a minute to get connected and logged in. Today, we will be talking about guardianship, and probably 30 to 45 minutes. We need to visit about guardianship, kind of what it is, and get a good overview of how it works here in Texas. Couple administrative matters let's talk about first is we do have everybody muted, and we want everybody muted because we don't want echoing in the background. And if there's equity, that way it's clear and everybody can hear and understand what's going on a little bit clearer. We also have the video muted as well. And just in case you become unmuted, be aware that other folks might be able to see you if you become unmuted on your video. But the way we have the settings right now is everybody should be able to see me and hear me, even though I can't see you or hear you. And so keep that in mind. You guys are welcome to answer questions throughout the presentation today, but use the chat feature on the Zoom video. And at the end, when I get done visiting with you guys about guardianship, we'll just kind of skim through the chat and see what questions there are and try to answer some, but keep them general in nature because this is a very general presentation. We don't want to get into too specific personal legal advice, and other people are listening as well, and so it wouldn't be private or confidential. So keep questions in a general nature. All right, let's get started talking about guardianship. We're going to share with you now some slides so that you can see and what we're talking about as we go. First thing I want you to know is that what a guardianship is generally in Texas. So generally a guardianship is a legal process where one person goes to court and gets appointed by the judge and they get legal authority to take care of somebody else, all right? And to that end, let's talk about a couple of terms we need to understand. Guardianship and ward, all right? Now, so in a guardianship, we have a person who's the guardian, and then we have a person who is the ward. The guardian is the person who goes to court, gets appointed by the judge to take control and to be able to take care of someone else. That's the guardian. And so the ward is the person that is being taken care of. That's called a ward. And the guardian then takes care of the ward. So let's make sure we understand that. So guardianship then is a legal process by which a person goes to court, gets appointed guardian over another person who's called their ward. I want you to think about that as in the nature of a parent-child relationship, all right? Once somebody becomes the guardian over a ward, they become like a parent to that ward. They have a legal responsibility and a legal duty to take care of their ward. And if they don't do so, they could get in trouble. You know, right now, if I had my mom and she needed help, I would be under no legal obligation to help my mom, all right? If my mom lived down the street or lived in a different town and she needed help, I could swing by and help her. I could take her to the doctor. I could buy her clothes. I could help pay her rent if she needed help paying her bills. I could do whatever I want to help her, but I would not be legally obligated to do so. I would not have a duty to take care of her. But if I become her guardian and I'm appointed by the judge to take care of her and she's my ward, I now have a legal duty to take care of her, just like a parent has a legal duty to take care of a child. So keep that in mind and think of a guardianship in terms of a parent-child relationship. Even though it's a little bit different, the duties are very similar. All right. In our practice, we see guardianships in three situations or three scenarios a lot. The first scenario we see them is when we have a minor child who turns 18 and has some sort of permanent disability, autism, cerebral palsy, even intellectual disabilities, some sort of disability that makes them unable to take care of themselves by reason of some sort of mental incapacity. And because of that, they now need their parents to continue managing their money or their property, their medical care, their shelter, and their food. They still need a parent. And we see that circumstance a lot. The second scenario that we deal with a lot for guardianships is where we have an adult who's injured in some sort of accident. most often it's a car accident, but we've had other accidents too. We worked on a case a couple of years ago where a gentleman fell off a ladder, fell on his head, and was permanently incapacitated because of that fall. And they then required a guardian to help him. And then our probably most common scenario is the third scenario, and that's where we have an adult who experiences the onset of incapacity later in life, usually. Alzheimer's, dementia, mental illness, or even, just a stroke. These things can result in some sort of disease process that results in one of us, our parents or our spouses, becoming unable to make good decisions, unable to manage our finances, unable to take care of our health care, and as a result, we need a guardian. And so these are the three situations we most often see the need for guardianship to arise. A court may appoint a guardian of a person or of the estate or both. So in Texas, we have two separate kinds of guardianships. It often looks like one guardianship, but the reality is we have two guardianships in Texas. We have a guardianship of the person and then a guardianship of the estate. The guardianship of the person is responsible for the body of their ward, right? They're responsible for making sure there's food, clothing, shelter, medical care, all of the things that relate to the physical well-being of the person, all right? That's guardian of the person. Guardian of the estate is the guardian of someone's money, someone's property, someone's belongings. That's the guardian of the estate. And usually the same person serves in the capacity as both the guardian of the person and the guardian of the estate. So it looks like one guardianship, but it really is two, all right? So usually only one guardian can be appointed per guardianship. And what that means is that one person's in charge of the guardian of the person, one person's in charge of the guardian of the estate. It's usually the same person. But it doesn't have to be. We've had scenarios and situations where we've had separate persons as guardian. I recently worked on a case where we had two daughters taking care of mom. One daughter lived with mom, and the other daughter generally tried to take care of money and was more business oriented. So we had the daughter that lived with mom appointed as guardian of the person. And then we had the daughter who lived in a different town appointed as guardian of the estate. The two of them get along. They wanted to take care of their mom jointly. And this is a way for them to both serve as guardian for their mother and to take advantage of their respective strengths. Now, there are some exceptions to only one person being appointed as a guardian. The court will appoint co-guardians in some limited circumstances, and they generally make sense. So, for example, if you have a husband and wife seeking to be guardianship of their child who's disabled turning 18, the court's going to appoint co-guardians. Likewise, if you have joint managing conservators over a child who's turning 18, the court's going to appoint both of them as co-guardians. We all have, occasionally, there are other states where mom and dad or brothers and sisters have been appointed as guardians of our sibling, and then they move to Texas and want to transfer the guardianship in. Texas will allow co-guardians to continue to serve had they been appointed as co-guardians in a different state. And then occasionally you'll have a situation where parents are separated, child turns 18 and is disabled, and they want to serve as co-guardians. That's another circumstance where we often have co-guardians appointed. So how do you initiate a guardianship? How do you go about doing that? Well, the right person has to apply to the court to be appointed as guardian. It has to be a person who's interested in the well-being and or the estate of the proposed ward. So that's how you initiate, that's who's eligible to initiate the guardianship. In some of the bigger counties like Dallas County, Harris County, Travis County, they have probate courts with large guardianship staffs. And in those counties, they have court-appointed investigators that are on the staff of the court budget. And in those situations, sometimes the court will get reports or complaints from Adult Protective Services or other individuals or agencies, and they may initiate a guardianship on their own. But in the smaller counties like Waco, McLennan County, Texas, Central Texas, North Texas area, usually somebody has to bring an application to become appointed as the guardian. Now, when you apply to be appointed as guardian, the first thing you have to be able to show the court is that the proposed ward is incapacitated. that they suffer an incapacity, meaning that they lack a legal determination or ability to take care of themselves. They lack mental capacity to do so. And that could be anything from making healthcare decisions to making complex financial decisions to making any kind of decision at all. There's a varying degree of incapacity. But in order to get a guardianship, you do have to show the court that the ward or the proposed ward suffers from some incapacity, partial or total incapacity. And in doing so, the court is going to want to look at the person's ability to feed, clothe, and shelter themselves, their ability to take care of their physical health, their ability to manage their property, their house, any land they own, their financial affairs, their bank accounts. All of that is going to be considered by the court on whether or not they're able to manage that. Once you show the court, or you believe that you can show the court that indeed the proposed ward that you think needs a guardian is indeed incapacitated, then you have to be able to show the court two more things. First, that there are not other supports and services that are taken care of or can take care of the ward. And second, that there is not a least restrictive means available. So in Texas, 2 or 3 years ago, there was a policy shift. Prior to that, it was pretty easy to get a guardianship. If somebody was incapacitated, you just go down, show the judge, hey, this person incapacitated, I fit the statute as qualified to serve as guardian, appoint me, and they could get appointed. 2 or 3 years ago, that we had a policy shift, the legislature met, the state's code changed, and they started saying, okay, look, we don't want guardianship to be too easy. We don't want to restrict people's movement or their rights to control themselves or their right to self-determination. We want to keep that available to individuals in Texas as much as possible. So even if they're incapacitated, we want to see if there's supports and services available to take care of them, and are there other alternatives, other ways to make legal decisions for this proposed ward than appointing a guardian. And so part of the guardianship process is we have to say, hey, judge, we've looked at this very closely, and there just are not any supports and services here in Waco or here in Bell County and Killeen or Temple or Georgetown, wherever we might be. There just are not supports and services available to take care of the proposed ward, whether that's our mom, our father, our spouse, whatever the case might be. Judge, we've looked. There's just nothing out there that can take care of them for us. We need to be able to do this. What the judge is looking for is there a way to get them, food, clothing, and shelter without a guardianship? Is there a way for them to manage their health care without somebody else being in control of it, or their financial affairs, their right to vote, their right to choose where they live? So those things have to be considered. Next, of course, you have to prove, is there a least or less restrictive alternative than a guardianship? Because like I said a few minutes ago, we want to intervene in people's lives in the least restrictive manner necessary under that person's circumstances. We want them to remain in charge of themselves, and we want to resist total disempowerment. So let's think about guardianship of the person. If we were applying for guardianship of the person, what are some potential less restrictive alternatives? A medical power of attorney would be an example of one. If the proposed ward had prepared and made a valid, good medical power of attorney that named an agent that was still capable and willing to serve, that might be an alternative, all right? Along with a directive to physician, which we often refer to as a living will, those two documents together would work to help allow an agent to make medical decisions, healthcare decisions for an individual without perhaps the need of a guardianship. Sometimes court health mental services might also be a less restrictive measure if the incapacity is a result of a mental illness. If it doesn't have anything to do with mental illness, that wouldn't be available or helpful. What about a guardianship of the estate? There are some less restrictive alternatives that might be available. Again, a power of attorney, a durable financial power of attorney. Now, it has to be durable. In one of our other webinars, Elisa explained the difference between a durable and a non-durable power of attorney. But durable means it has language in the power of attorney that says if the individual or if I become incapacitated, my power of attorney remains valid. I still want my agent to be able to make financial decisions for me that I authorize in my power of attorney. That's durable power of attorney, okay? So if the proposed ward has a valid, durable power of attorney, then we might not need to do a guardianship of the estate because we have the ability to make decisions for that person with regard to their estate. Now, occasionally, there still might need a guardianship even if there's a valid power of attorney, because sometimes the agent becomes unavailable or unwilling to serve. Sometimes there's a concern that the agent is not managing the ward's money appropriately. And so if those are the kinds of scenarios going on, we might still want to move for guardianship of the estate. Likewise, sometimes the power of attorneys are too limited. And when the person created them, they were really concerned about granting too much power, and the family can't take some of the actions they need under the power of attorney to financially secure assets or get public benefits for the individual who's the proposed ward. And we still might need to move forward with a guardianship of the estate, even though there's a valid, durable power of attorney. Other alternatives could be trusts that were created by the individual before he or she became incapacitated, or trusts that were created by the family or even by the court. You know, oftentimes, especially in injury cases, where someone was injured and there was a lawsuit for personal injury, we can have the court create a trust that would manage the money for that person's benefit and avoid the need for an estate, guardianship of the estate. Another thing to be aware of is a neat tool we have in Texas is where we have community property administration. So that often can avoid the need for guardianship of the estate. We might need to get a guardianship of the person, but the spouse could then be appointed community administrator, not guardian. And if you're a community administrator, that allows you to sign your spouse's name and manage your spouse's share of the community property in the estate, even though your spouse is incapacitated. So if you needed to sell the community property house or the car in your wife's name, or take other steps to manage community property, you could do so as the community administrator. There are some advantages to being the community administrator. Usually you don't have to have a bond. And usually you don't have to do accounting every year like you do with a guardianship. So it's something to keep in mind. Another alternative to a guardianship of the estate sometimes is whether or not we could be appointed representative payee for Social Security. Social Security has their own system for Social Security payments where they will appoint a person to be representative payee of an individual's Social Security monthly check. If you're the Social Security's representative payee for somebody, every year you have to report to Social Security what you did with funds that were paid to you on behalf of someone else. And you have to show that it was spent for them. So a representative payee might be a way to avoid a guardianship of the estate. And then, of course, if there's veteran benefits that are at issue, we can ask the VA to appoint a fiduciary over the veteran's benefits. And that may be a way to avoid a guardianship of the estate also. It just kind of depends on what else there's involved in this person's estate who we're considering as a ward. Other things we need to consider when we start talking about a guardianship, all right? Is this person who we think is incapacitated, are they completely incompetent or partially incompetent? That really, you know, that goes back to what we were talking about earlier. We need to evaluate, have they lost the ability to make complex financial decisions, but still have the ability to buy groceries, you know, but not really understand the difference between mortgages and financial investment decisions, right? We need to kind of evaluate that. We also have to give some serious thought if we're looking for guardianship of the person about, does the person retain the right or the ability to get married or to fall in love with someone else? Should they be allowed to drive, or have they lost that capacity? What about voting? You Just because someone has dementia doesn't mean they can't vote anymore, especially if they're a lifelong single ticket voter, right? If mom has always voted Republican or always voted as a Democrat, maybe we still want to leave her the ability to vote in elections because she's just going to do a single ticket vote and choose the same as she has always. So those are things we need to consider when we're pursuing a guardianship, when we're talking about whether or not mom or dad or our spouse or our sibling is able to eat, medicate, or toilet themselves, dress themselves, determine their place of residence, are all things that we can customize in our guardianship order, leaving some ability to the ward to make decisions for themselves, leaving some ability to the guardian, or taking away some abilities from the ward and giving it to the guardian. So all of these are types of things that really we need to give thought to when we craft an order. You know, a lot of times when we're pursuing a guardianship on behalf of a family, mom or dad or the spouse or the child turning 18 is very clearly incapacitated and really doesn't have the capacity to do anything. And in that case, these considerations are very easy, right? It's simply, okay, let's get a total guardianship and let's go and get it taken care of. But there are times when we have a mom or a dad or a spouse whose capacity is waning. They clearly can't make financial decisions. They're not capable of signing a new durable power of attorney because they can't understand what it does. But maybe they can still vote. Maybe they can still get married. Maybe they can still decide what clothes they wear and things like that. And when we draft our guardianship order, we might want to leave that power to the ward. All right. How about who can be appointed as the guardian? Like we talked about earlier, it's got to be somebody interested in the welfare of the person or interested in their property and preserving their property. And generally in Texas, we have a law or a statute that says the spouse is first priority. The judge, the court is going to appoint the proposed ward spouse as the guardian. And that's just a presumption right off the bat. The judge will not appoint the spouse if the spouse is not capable of serving, all right? So if the spouse is frail, you know, if we have a couple and wife and husband are both elderly and frail, they both have some onset of dementia, it's just that one is quite a bit worse than the other, but they're neither one are capable of taking care of the other, then the judge probably would not appoint the spouse as the guardian. But otherwise, if the spouse is capable and wants to be the guardian, that's who the court will appoint as the guardian. Then the statute's kind of successive in nature. The children are next in line, all right? So if the children want to serve, they would be next. And then it just kind of goes down in line of the next of kin. If there are no family members, then it has to be somebody who's interested, somebody who can show the court, I'm a close family friend. I'm a cousin who's always been there for this person. You know, I'm a joint property owner, and so I need to help her take care of the estate. Some sort of interest like that. Also of noteworthy is the court must make a reasonable effort to consider the proposed ward's preferred guardian, all right? This comes up in a couple situations. When you are making a will, you might designate who you want to be appointed as guardian for your minor children in the event you're killed in a car wreck or some unfortunate accident. If that happens, then the judge is going to take your request seriously and is going to appoint who you want to be named as guardian for your minor children. But also, when you're an adult, you can make a declaration in writing saying, if I ever need a guardian, I want this child or I want my spouse to be appointed my guardian. And then if there ever becomes a contest between children or between a second spouse and children as to who the court should appoint as your guardian, your decision that you made in writing when you were competent will be the deciding factor. So that's a very helpful document, and it's something to be remembered. People who cannot be the guardian. Minors cannot be a guardian. An incapacitated person cannot be a guardian, obviously. This third one on the slide here is a person whose conduct is notoriously bad. And then down a little bit, you see where a person found unsuitable by the court. Usually somebody with a criminal record, especially felony record, this is going to usually disqualify them from serving because a court 9 times out of 10, 8 times out of 10 is going to find criminal conduct to qualify as under one of these sections, meaning they're disqualified. Now, I have had clients appointed as guardian who have had some sort of criminal blip on their record 20 or 30 years ago, and then have been model citizens since then. So it's not an immediate and automatic disqualifier, but it is a disqualifier. Likewise, conflict of interest. And then right here, the second to last listing, disqualification by the declarant's ward. That's important to note because a few minutes ago, I was explaining to you that we could declare in writing who we would want to be our guardian. We can also declare in writing who we don't want to be our guardian. So if I said in writing, I do not want my daughter to be my guardian. She is not financially secure. She spends money left and right, and I don't like her husband. Well, if I put that in writing, then that she will be disqualified and cannot serve as my guardian. Everybody has to have a criminal background check, even family members. A few years ago, family members were not required to get a criminal background check. Now, anybody who applies to be a guardian has to do a background check. Now, we talked about the requirement for the ward to be incapacitated. How do we show that to the judge? Well, we show that to the judge by getting a certified medical exam. Texas has a form that they've promulgated that they would like a providing physician, a primary care physician, or a treating physician for the proposed ward to complete, and that form has to be filled out, attached to, and filed with the court along with the application for guardianship. It has to have been dated within the last 120 days before filing the application for guardianship, and it has to be based on a doctor's visit within that same time period. You know, every once in a while, I'll have someone bring me a doctor's letter on a case that we're pursuing guardianship, and the doctor will have done it within the last 30 days or even after our first initial consult, but it will be based on an exam done a year ago, and that's not going to suffice. There has to be a recent doctor's visit that forms the basis of the certified medical exam. The one thing that's different, if we're getting guardianship based on an intellectual disability, then the exam can have been over the last 24 months. But if it's based on anything other than an intellectual disability, there's this 120-day requirement. We also need to note that if we're trying to say to the judge or to the doctor that mom or dad is crazy, they're gone berserk, they don't know what they're doing, they ran outside naked, that by itself on a 1 time or 2 times is not going to be sufficient to show incapacity. It's going to be reoccurring acts and occurrences within the last 6 months, okay? 1 or 2 incidents of what might seem like crazy conduct isn't going to be sufficient by itself to declare them as incompetent. Once we filed the application, we've gone through all the requirements we've talked about so far. Then what we do is we have a hearing set, and at the hearing, the judge has to determine whether or not he should grant guardianship. Now, one thing that I haven't talked too much about is a part of this process, the court is going to appoint an attorney ad litem, and the attorney ad litem is going to be required to meet with the proposed ward, and the attorney ad litem is going to be required to meet with the person, the applicant seeking to be appointed guardianship, and the attorney ad litem is, of course, going to talk to the attorney who's representing the applicant for it. And so the attorney ad litem will have investigated the case, will have reviewed the physician's medical exam that we talked about a few minutes ago. The attorney ad litem may ask for additional medical records if they feel like that report's not sufficient. The attorney ad litem will go and visit with the proposed ward in person usually, or under today's current conditions, maybe by Zoom. And then the attorney ad litem will file a report and tell the judge, yes, I agree with the applicant that a guardianship is necessary. There's no really supportive services. There's no least restrictive alternative available, and a guardianship's appropriate under these conditions. So at the hearing, the applicant will be present. the attorney would be present for the applicant, the ad litem would be present, and the ward. The ward needs to be at the hearing also, unless it doesn't make sense for the ward to be there. And then the judge has to make a finding that the ward does not need to be at the hearing. After the hearing, the judge makes a finding that a guardianship is appropriate and that the person lacks capacity. The judge has to make a finding whether the capacity is total or partial, and then the judge has to sign an order that determines that. So occasionally, we have cases where we make a finding, the judge makes a finding that the incapacity is only partial in nature. And so when that happens, then the court has to make fashion in the order, I'm going to allow the ward to retain the right to vote, to marry, to drive, to dress themselves. Those types of powers that they're going to allow the ward to keep, the judge will identify those in the court order and then give rest of the powers and rights to the applicant who's being appointed as the guardian. Once they do that, the clerk will issue letters of guardianship, okay? Letters of guardianship is an official certificate by the clerk of the court showing that the judge has appointed an individual as guardian over this proposed ward. And the guardianship letter will say on it whether or not it's a guardianship of the person, guardianship of the estate, or both, all right? But before the clerk will issue the letters of guardianship, and after the judge has had a hearing and ordered and approved the guardianship, the applicant for guardianship has to get a bond, all right? Now, the bond secures and protects the ward against mismanagement, against waste, or fraud by the appointed guardian. So the bond is going to be required for both guardianships, guardianship of the person and a guardianship of the estate. The guardianship of the person, the bond's going to be not very big. It's going to be maybe here in McLennan County, our judge usually orders $1,000 to $2,000 for the guardianship of the person. But the guardianship of the of the estate is determined according to what the ward owns, right? So they're going to look at the value of all the personal property, including money and financial accounts. They're going to look at what the ward is going to earn in Social Security, retirement, or other earnings, including interest or dividends over the next 12 months. They're going to add all that up. They're going to subtract out Social Security payments, okay? And then that's going to give them the value of the bond that the judge is going to order the guardian to make. The guardian then needs to go to a bonding company and get a surety bond or a corporate bond in that amount, has to file that with the court. The court has to approve it before the clerk will issue the letters of guardianship. The bond, is required, period. It can't be waived in most circumstances. Now, if I had done a declaration of guardian or I had done a provision in my will for minors, I can waive a bond for the guardianship of the person only. So I can waive the requirement that if somebody's appointed guardian of the person of me or one of my minor children, they don't have to have a bond for guardian of the person. But I cannot waive the bond for the estate. So that is required. Now, a trust company or a guardianship program operated by the county, they don't have to put up a bond. So very important to keep that in mind. Now, every year, once you're appointed guardian, you have to file a guardianship report of the person and an accounting with the court in order for it to be renewed. The guardianship is just good for 1 year. The court requires that if you're guardian of the person, that you report to the court on a once-a-year basis what's happened over the last year with the ward, who the doctor is, what kind of activities the ward participates in, and how often you as the guardian are visiting with and seeing your ward. They want to make sure that you don't take your ward, put them in the nursing home and forget about them, all right? So they want to make sure that you're actually taking care of your ward, and they want to report and they want to see and know what's happening to your ward. Same way with the estate. When you get appointed guardian of the estate, you have to file an initial sworn inventory with the court outlining what the assets are And every year you have to account to the court what's happened to your ward's assets and to their income, what bills you paid, what bills you didn't pay, and how much money is left in the estate every year. And then once you do those two things, the judge renews your guardianship letters for another year. So those are annual requirements. You should note that you have a duty of care as the guardian of the estate to manage your ward's estate as a prudent person would manage their own estate. All right. You can't say, well, I would have just put the money in a savings account earning 1% and left it there, and I wouldn't pay these bills because I don't think they're important. That's not going to be good enough. You're going to have to say, what would a prudent person do to manage this money? What would a prudent person do to make sure bills got paid on behalf of the ward? That's your duty of care. Now, that's a general outline of guardianship and the process and how it works. Two more things I want to talk to you about just for a moment that kind of are important parts of the guardianship process and are available. Family visitation. We can, in a guardianship proceeding, order access rights, visitation rights to other family members in a guardianship case. I recently worked on a guardianship case where three sisters were fighting with each other over who would be the guardian of mom. They all truly seemed to have the best interest of mom. They all wanted to take care of mom, and they couldn't reach an agreement on who would take care of mom. So we had to have a contested hearing. And then after the hearing, my client was named guardian, and the other attorney then filed a request to have his client granted specific court order visitation with mom. And the judge granted that request and ordered it. And it was probably a reasonable thing to do because the sisters were already not getting along. Then they have a contested guardianship. They're not going to get along after that. So this way, the judge ordered specific dates and times, like 3 or 4 times a week for an hour or 2 at a time, when one daughter would be available to go visit mom at nursing home all by herself and know that she will be undisturbed by her sisters. And so that's certainly available to do in a guardianship proceeding, and we all need to know about that. I want to tell you about a temporary guardianship real quick. In Texas, we have the ability to get a temporary, which is sometimes called an emergency guardianship. So if we are concerned that mom or dad or our spouse or a sibling or someone is making very bad decisions because of their dementia or Alzheimer's and are just giving away money to scammers, and they're about to give away their whole estate and won't have money to take care of themselves, we can file an immediate and emergency application for guardianship of the estate. If we're concerned that somebody is taking advantage, same thing, of mom or dad, or if we're concerned that they're making very bad health decisions and are going to hurt themselves, we can do that as well. But we've got to show the judge that there's probable cause to believe that an immediate guardianship is necessary and that the person is incapacitated and that its imminent harm would occur if we don't get the temporary guardianship. All right. It isn't enough to say mom or dad is incapacitated and we need to get guardianship. That's a regular guardianship proceeding. For an emergency or temporary guardianship proceeding, we have to say there's going to be imminent harm to our mom or our father or our spouse unless we get guardianship now, quickly, within the next 2 weeks. So that's the big difference. Even after we get a temporary guardianship granted, we still have to put up a bond, and then we still have to go forward and meet the rest of the permanent guardianship requirements. So keep that in mind as well. But this is out there, it is available, and from time to time, we have helped clients with temporary guardianships. In fact, right now, we have 2 different clients considering applying for temporary guardianship because of the COVID-19 and the coronavirus circumstances. It's the only way we might be able to get them served. And so that there are times when we want to use a temporary guardianship. It's really most of everything I really wanted to visit with you today about. If you would like to get a copy of the slides, contact us at marketing@raineyandrainey.com, and ask for a copy of the slides, and we'll be happy to email you a PDF format for a copy of the slides. Did you stop? All right. I think we're going to look now and see if we have any questions on the chat, and see if there's any questions we can answer for you. Let's take a look at that. All right. So let me see here. All right. Hold on. My chat feature is hold on one second. Let me try to get the chat opened.